this. So we're good?
Yeah.
All right, so welcome guys to regulation of tax practice. I'm Jay Solid. Hopefully, not all of you I know, most of you, or many of you, have been able to get a copy of our textbook, and I know for some people, Trevor, I think yours is on order, right? Fingers crossed, Monday, Tuesday?
It was supposed to be today, so.
All right, so did you order yours?
Yeah, I have the ebook.
All right,
You
but
have that physical?
the idea is the exam is open book, but it can't have any electronic devices, so you gotta get a physical one.
Okay.
All right, so when you can, make sure you get the physical one. Good news, for those who've had tax courses, you do not need to get a new one. You can use your existing one. Most of you have this. If you don't, you should make sure you have it.
Which one is that one?
What?
Which one
The
is that
income
one?
tax, just general statutes, the code and
You need that one as
regulations.
well?
Yeah. All right, you should. Ideally, for most of you, if you take this course or any other tax course this year, I would recommend getting the 2019 version, okay? Because if you get the 2018 version, the 2018 version does not have the changes to the 2017 Tax Act. So I will leave this up here during the break. We'll break around 10:30, quarter of 11. So if anyone doesn't have this or needs to get the ISBN number, you'll check it out. I have two other books that I recommended that you could consider, you don't need to get, you could consider getting. If you get an earlier edition, you can get, these books have not changed much, so don't pay big bucks to get the latest and greatest. If you get an earlier edition, you'll be fine. And the cost, I'm making this up, many times in Amazon, the earlier editions cost like a penny and they charge $3.99 for shipping. Those will suffice. And this other book, Practical Guide to Federal Tax Practice. Again, I wouldn't get a version that was published in 1999, but if you get a version like 2012 and on, that will be fine for our purposes. Consider, you don't need to get these, but consider if the price is right and you're comfortable. Definitely the code you should have, because any tax accountant in the world isn't worth a dime if you don't have this. And I always point out, if just carrying it, you'll build physical, not mental stress.
I didn't see that one on the business.
You know why? I always just assume, all right, Peter, that hey, it's who wouldn't have this, right? Given our profession, so maybe it's implicit on my part. But the textbook you guys should have, and make sure if you could bring it regularly to class. As the semester unfolds periodically, I will bring written material to distribute to you. If you're not going to be there for a particular class, if you could befriend someone to your left or your right and ask that person to help you as the semester unfolds, if for some reason you can't make it, and he or she can be your proxy and get a copy of that, that'd be great. So I don't have to try to remember who wasn't here and who needs copies of things. So if you can develop that, that'd be great. Some logistical things. I just ran downstairs. I'm hoping going forward, Janet, who is the woman in charge here, said that the doors should be open, but nevertheless they aren't open. She's going to try to make sure that doesn't happen again, fingers crossed. This is my first time here, so most of you is your first time here, so I'm just getting the lay of the land. I got a quick tour when I was downstairs. I'm happy to, during our break, to lead you guys to the promised land. What is the promised land? Vending machines downstairs. Today, I brought, I'm not going to call it health food, but Dunkin' Donuts, if you guys get stuck or you're starving, you need your sugar fix. We'll break these up open during the break. Just bear in mind in terms of many of you, some of you I should say, have had courses at Drew University with me. Drew it's not too far from here, but in terms of things that are more located here, Friendly's, if you, depending on how you came, Friendly's restaurant is right, pretty much across the street from here. So on your way here, you might consider if you need coffee or something, it's right there. And then 3 minutes from here, if you make a left out of the exit, and you keep taking, what street? Madison Avenue. And at the very end of Madison Avenue, you make a right. About 3 minutes from here is a Whole Foods. So if you need some other kind of fix, there is a Whole Foods very close proximity here. So those are the two that I think are viable, that are easily accessible. So let me just tell you who I am, and then if we could quickly introduce ourselves, just be curious who you are, where you work, where you live, and sort of what background you have in tax, that'd be great. And then we'll get right into the textbook. So Jay Solid has been teaching at Rutgers for over 20 years. When I'm not teaching, and I teach income tax, corporate tax, income taxation to trusted estates, international tax, this course, estate and gift tax, try to teach a whole array of courses and have a lot of fun. Always busy publishing, trying to write the latest and greatest. In fact, as this semester unfolds, I co-authored an article with Michael Lang. So that was just about 2 years ago. We worked on a piece together. And when I'm not teaching and publishing, I have an office about 10 minutes from here in Cedar Knolls where I actually practice what I preach. So I have way too many war stories for you guys, which I'm happy to share. So as the semester unfolds, and it unfolds quickly in this course, I will periodically share some of my stories. And I live 10 minutes from here as well, up in Randolph, New Jersey. So anyway, and if I mispronounce your name, I apologize in advance. So, it's Omar?
Yes, my name is Omari Williams.
Omari, I
Yes.
gotta add the E, Omari,
Yeah,
right?
it was an I, but it's pronounced as E. Yeah.
All right,
Yeah.
gotta help myself. Okay, so if you see the I, it stands for E, Omari.
Exactly, yes.
So tell us, Omari.
Yeah, so my name is Omari Williams. I'm from Hackensack, New Jersey. I work at the School of Communication and Information on the New Brunswick campus as a budget analyst. And this is the first tax course I'm taking.
All right.
My interest is basically getting credits I need to sit for the CPA and focus on tax.
Terrific, welcome to Rutgers. Brian?
I'm Brian. I work at Wisdom Smith and Brown down in the East Brunswick office. I live in New Brunswick, and what else do you know?
What kind of tax do you specialize in?
I don't specialize in anything specific right now, but I do everything from personal returns to nonprofits and partnerships and all that stuff.
All right. It's the pronunciation. What?
Oh, Devontae.
Devontae.
Good morning, everyone. My name is Devontae Reach. I'm currently a tax collector for the state of New Jersey, and I'm from Trenton, New Jersey.
All right, so you have a commute every day here. All right, so just your helicopter's parked outside.
Yes.
Trevor?
Trevor, I work at Wisdom Smith and Brown. I don't know Brian.
You don't?
No.
Different offices?
I'm from New York office, but I actually work in East Brunswick a lot because I'm on a project.
Brian, meet Trevor.
Sit outside in his office. You know,
So, Trevor, what kind of tax do you
Nina?
specialize in?
Nina?
yeah, I don't. So I do everything.
All right, sounds familiar. All right. And you live where, Trevor?
Long Branch.
All right, so you too have a commute.
Yep.
All right. Viva?
Hi, my name is Viva Lord. I'm living in Avison, New Jersey, and I'm also working with the tax preparation for individuals and corporations.
Dixie?
Hi, I'm Dixie Thomas, and I'm from Morris Plains. I'm currently not working, but I'm starting an internship by Monday. So,
Congratulations.
My name is Peter Carey. I live in Liberty Township, which is in Warren County, closer to Pocono, living down that way. I worked for the state of New Jersey for about 13 years, did a lot of auditing. And for the past 10 years, I've been working with a small CPA firm, and it's just 1040s, 1120s, personal business returns. I definitely want to sit down with
We got someone first class, someone last class. All right, and Ping?
Okay, I'm Ping Ying, and I work at the Barnabas House, internal audit. Now, this spare time, the little bit tax return. For me, it's like this one is my retirement job.
All right, and where do you live, Ping? I forget.
Melbourne.
Melbourne, okay. Andrew?
Hey guys, I'm Andrew. I live in New York, so that was kind of a long train ride too. Disappointed this wasn't in New York. But it is what it is. I work at in the private banking space in New York as well. Also working with high net worth, charitable foundations, and things like that. So.
Gotcha.
Hi, I'm Maite. I live and work in Hasbro Heights and a small CPA firm. I do taxes.
Gotcha. V?
My name is Vandana, but everyone calls me V. I live in Hoboken, New Jersey, and I do not work in tax. I'm doing this just as to see where it takes me, and I teach part-time.
If you guys ever, I will give a shout out. V has on YouTube a little comedy skit about why she's called V and not her full name. So you look up Vandana Sinha.
Huh.
Do a little Google search on YouTube, or you can watch it for yourself. All right, so we're going to go through the entirety, a little heads up here, the entirety of this textbook. So good news, we're going to try to make your time Saturdays and Wednesdays well worth your while in the commute here. So we're going to start from page 1, and hopefully if history is any indication, make it through the entirety of the book. I have scheduled 3 guest speakers that will come and discuss different facets of some of the attributes of this book. So let me just give you a heads up on my planning here. Is that on Wednesday, this upcoming Wednesday, if things fall into place, we're going to have someone do a presentation from RIA about tax research, because the course itself engenders you taking an exam in 10th class and also preparing a 3-page paper. So it's not heavy duty, but I feel it's important for everyone in the program to have some exposure to some tax research. So we're going to have, and everyone here was able to get an RIA number. Let me just make, yes? You saw my emails.
What
No?
number?
Most of you, because I did on Blackboard. You guys have been getting my Blackboard messages, and I sent an email out that Anthony Perchese was supposed to, you're supposed to secure RI checkpoint pass. So some of you got that. If you haven't, shoot me an email on Monday, and I will get that over to Professor Perchese, who will get you an RI checkpoint password, which is invaluable.
I have it from the Thomson.
Thomson Reuters.
Yes, I have it.
You got it?
Yeah, I got it. Every day I play.
All right, that's important, because on Wednesday, you should bring your laptops with you, all right? Everyone should come to class with a laptop, all right? And we'll log on using their Wi-Fi, and just have someone give an hour or so lecture on RIA Checkpoint, because if you haven't used RIA Checkpoint, it's truly a tremendous tool to get access to just virtually anything in the area of taxation. So I want to make sure everyone knows, as long as you're part of Rutgers, you have free access to RIA Checkpoint. Normally, practitioners pay anywhere from $7,000 to $10,000 a year for such access. So it's truly a tremendous attribute of the program, and your ability to leverage to your benefit. So if you don't have that password, let me know. We got to get you one before class on Wednesday, because the person who's coming, to my knowledge, will not be able to just give you access. So so it will be frustrating on your part if you don't have it. So we'll have one speaker on Wednesday. A week later, I'm hoping we have a speaker talk about criminal law and what are some of the things that you and your clients have to be wary about in terms of criminal issues pertaining to, which doesn't, criminal aspects of tax do not come up much in any of the tax courses I teach, but it's one of those things that everyone should be aware of. On a number of occasions recently, I've had clients get themselves into some really awkward situations where they have some criminal exposure. So we can talk more about that in the weeks to come, but it can happen to you, hopefully not happen to you, but it can happen to your clients, particularly overseas accounts. Because a lot of clients, at least for the last 10, 20, 30 years, for one reason or another, have had overseas accounts and they have not filed their so-called FBARs or FinCINs. And right now they have potential criminal liability exposure. So you should be aware of that and what you should do or what your client should do under those circumstances. So we're going to have a specialist talk about that. And then in a week or two later, again, if everything falls into place, my goal is we typically have a gentleman, Tim Saya, who's truly gifted. He's a specialist in accounting malpractice, something that hopefully none of you will ever have exposure to, but sadly many of you will have exposure to, just because it's a very litigious society that we exist in. Anything that goes wrong, whose fault is it? Your fault. And so you've got to be aware of what you should do under those circumstances when it comes to accounting malpractice, when you should report it, when you shouldn't, what you can anticipate if you are sued. And I can give you a little foreshadowing if it makes you feel any better about this. I've been there. I've been on the other side of a V, and I'm where plaintiff versus Solid. All right, so I've been so it makes you feel any better. I lived through it. So a lot of times, one of the first things people will say is, "What happens when you get sued?" You have to say to the people, and I mean this, breathe, because when you first get that certified letter that you're being sued, you feel like the wind taken out of you. So you'll see. And I was not sued for. I'll give you a little more foreshadowing, but I won't tell you the end of the story. $2 million. So it wasn't $10. It wasn't $20. It wasn't $2 million. All right. And that wasn't the only. That was one official suit. There was some other people who fished around, but again, we'll get there. And I just want to make sure you guys pay attention on a Saturday morning, and also again to share some of the stories that I've lived through. So we will get to those guest speakers. Okay, so we have at least 3 guest speakers lined up, and what I intend to do. Most of you. Is anyone not on Blackboard? Now I know, for example, Omri, did I say that right?
Omari.
Omari.
Yes.
Omari. 3 syllables.
Yes.
Omari, did you get my Blackboard messages?
Yes, I
Did anyone not?
I have.
All right, because you're not registered yet, but that's gonna happen. Okay. But I told you about today's reading assignment, so. But everyone else has, and needless to say, periodically check your email. I post announcements, sometimes send it out by way of just general emails, try to keep everyone in the loop. Ideally, everyone should have read the first 57 pages, but again, I know some people didn't have access to the textbook, or for one reason or another, couldn't get around to doing it. But if you could read the material, come to class as prepared as possible, that'd be great. It sounds to me like everyone's working in this room. Having said that, sometimes you're not going to be able to read the material before class because life will pull you in a direction that doesn't afford you that luxury. So be it. I mean, you got to stay employed, you got to keep the clients happy, so be it. I'll survive, you'll survive. For the exam though, hopefully you'll be as prepared as possible. And I'll talk more about the paper in another week or two. I don't want to talk about it yet because it's premature, but I don't want anyone to start start it yet because you're not ready to start it yet. So I think if we go through a few classes, and then I talk about the paper, everyone will be mentally in a better place. And it's not a, it's not a paper that's gonna take you forever. It's talking 3 pages, double spaced, it's all very doable, all right? So also bear in mind, it's not gonna be a 30, 40-page research paper, and we're gonna have a crunch time at the end. It's all should be very manageable. I try to be responsive to people's emails, so if you send me an email, anticipate a response. If you don't be bashful, resend it. Some reason I didn't receive it, type thing. I'm just trying to get room temperatures. First time in this room. Looks like, Peter, you're closest to the thermostat. I don't know if that is.
It's reading 75-ish.
Yeah, that's the problem. It's reading 75-ish. Can we cool it down? Do you have access?
I don't think we can. We have to do it on purpose.
Okay, I was just wondering. Anyone else? Monty, you're in a coat. I'm feeling warm looking at you.
I'm fine.
You're fine. I'm melting up here. I'm getting warm just looking at you in your coat. But I'll see if Janet, who's the woman in charge here, if we can get a little bit cooler. I don't want anyone to doze because of it's just too warm in here. But anyway, logistically, any questions before we start? Everyone's good? All right. So this is the second edition of the book. I know both Michael and Linda. Michael I co-authored with. Linda, periodically I've dealt with her on various issues. Janet? Quick question. Can we cool it down a bit? It's reading 75 degrees. Is there a magic to? Oh,
Bit lower.
okay. What did you watch?
I just pushed it down more just to get it to register.
There's something here? Okay, terrific. Thank you very much. So, this way. That sounds promising. All right, so if you don't mind turning to the table of contents, I always think is useful before jumping into the forest, is just to look at the table of contents, just so you get a complete lay of the forest. Okay. So, table of contents, if you have it open, starts with the introduction. By the way, one of my pet peeves, and by the way, like I said, I'm friends with Michael and Linda. When they had the first edition, I kept telling them, guys, you gotta get this book more user-friendly for accountants, because many graduate programs have both CPAs and lawyers, so try to broaden the breadth of the book, again, when I was looking at the first edition, to include accountants. So you will see, and they agreed with me that they needed to do that throughout the book, they've made greater efforts, greater strides to address the regulation of accountants as in addition to attorneys. But in some places they fell short, okay? My opinion. So the introduction to me would be the tax professionals' duties to the tax system, not just the tax lawyers, because again, most of you are not lawyers, if none of you are lawyers, but you all have a responsibility to the system. Chapter 1 is talking about sources of professional regulation, what regulates us as professionals, what differentiates us from the general public as tax accountants, what makes us unique. So one thing I want to call to your attention, just in this table, there is both state regulation and federal regulation. Keep in mind that there are state laws that govern how we practice, right? That are at the state level, state of New Jersey or New York, whatever state. And then the federal government has its own set of laws. So we're governed by two distinct set of laws which may apply, and the standards may vary. all right? And the sources may vary. So the federal, we're gonna see as Circular 230 is a sets parameters, and also the federal tax preparer penalties set standards. If you look at chapter 2, talks about tax return preparation advice. What are the parameters of tax return preparation and advice? And we see that, and students often, and I see practitioners often, make this mistake, hopefully you guys won't, that when you look at these standards, keep in mind, and I'll be repetitive because sometimes it resonates, sometimes it doesn't, that there are certain penalties that apply to taxpayers, and there are very different penalties that apply to tax return preparers, right? So, two sets of rules. One is found in Code Section 6662. Those are generally the penalties applicable to taxpayers. There's more, but that's in broad brushstroke, Code Section 6662. And then the penalties that apply to practitioners, Code Section 6694, are those penalties that apply to practitioners. So just bear that in mind in this class, outside the class for exam purposes. Don't use those penalties interchangeably. They're wholly different in nature. They have similar standards, but the penalties are different. And what the authors do in chapter 2, elaborate about what standards apply, deal with valuation and estimates, all sorts of things. All right, so that's chapter 2. Chapter 3 deals with transactional planning and advice. So keep in mind, chapter 2 is most of you spoke about tax return preparation that you're immersed in, but periodically you're going to be involved in transactional advice, right? Aside from preparing tax returns. So when you're advising clients from a transactional point of view, right? Tax season is only one part of the year. Transactional events can happen at any point. What are your responsibility with respect to transactional planning? Right? And those are elaborated in chapter 3. Chapter 4 deals with client confidentiality and evidentiary privileges. What are you required to do in terms of client confidentiality? And I'll mention this, I'm sure, again, but if you remember about a year ago, Trump tax returns, there were 2 pages released, and his former accountant, I think was located in Miami, was talking about the preparation of his tax return and query whether or not he said too much when he talked about the tax return. So we talked about that when we were talking about chapter 4. And then it also talks about practitioner privileges, okay? Practitioner privileges that we're supposed to adhere to, but what access does the government, what access does the IRS have to your work, okay? And how is that protected? And keep in mind, there's 2 different privileges that we're going to talk about. The attorney-client privilege, but the attorney-client privilege extends to accountants, in part extends to accountants. You made it.
Yes.
Okay. Did you have a problem getting in with the?
No, I got right in.
Okay.
Fine. Yeah.
Some people were having trouble with the door downstairs. And the work product privilege. So there's 2 privileges that protects information. The attorney-client privilege, which also now extends to accountants, and also the work product doctrine, which again restricts access to information. Chapter 5 deals with state regulatory issues. What's permissible, what isn't, and it covers things like the unauthorized practice of law. And you might say, and I'll, again, when we get into this specifically, don't think of the legal field, in my opinion, as separate and apart from the field of accounting. Why? Many of you will periodically work with attorneys on deals. And you have to just make sure that if the attorney you're working with is, how do I say, operating within the proper scope of his or her responsibilities as being a lawyer. So even though we're going to be covering some topics that relate, for example, specifically to lawyers, often you're going to be working with attorneys, and you have to make sure that that attorney is not violating. Because if there's a problem with the attorney violating, generally when people sue practitioners, they sue everyone. So you have to make sure that you're on the right side, even though it may not be necessarily your issue. So anyway, and Chapter 5 deals with a whole host of issues, including multi-jurisdictional practice, advertising, specialization certification, and the like. So it's a whole potpourri of various issues covered in Chapter 5. Chapter 6 deals with malpractice issues, which is not a favorite topic for many people because, oh, okay, you have a great, terrific, good news. And I don't have to do anything else, right, Janet? Just close. That's it. So if you guys want to end class early, we just, during the break, shut the door and we're done, because I will never be able to get back in. So just, let's not shut the door until class is really over, else I'll be in trouble. All right, so malpractice issues, guys, to me, for many reasons, your Saturdays and Wednesdays, my job, among other things, is to try to limit the number of times, maybe get you down to 0, the number of times, if ever, you will be sued, okay? Because being sued is not a lot of fun, a lot of mental stress and anguish and energy. So if we serve any, or I serve any purpose over the next several weeks, is to try to make sure that that doesn't happen, albeit even as we try really hard to stop that from happening, all bets are off. But if it does happen, at least you should get a flavor here of what you can anticipate, what are the standards, and again, we're going to have someone who specializes in this give you a pep talk on the do's and don'ts of accounting malpractice. So that gives you the objectives of what we intend to cover, and again, if history is any indication, we should be able to finish the entirety of the textbook. Any questions? All right, so let's just talk about the introduction, and then we'll just get into Chapter 1. Okay, so the introduction just talks in general about the tax lawyer's duty to the system, but like I said, this chapter, in my opinion, or introduction, could easily be broadened to include the tax professional's duty to the system, all right? Does not have to be limited just to a tax attorney. Talks about the fact, just generally ethical rules, that you have this opportunity to act with warm zeal towards representing your client. You're supposed to act honestly and ethically. All these things, to me, are things that, of course, everyone in this room would adhere to. The question that will be raised on pages 4 and 5 is that, unlike when attorneys or accountants represent people, let me just limit my conversation for a moment to attorneys. When an attorney represents someone, say in a buy-sell agreement, they have only one duty to only one person, right? Or to a corporation, to a partnership. And they know what that duty is in terms of being an advocate. When you play the role of an attorney in the context of taxes, query whether or not you really have a duty to the system, duty to the government. In other words, when you're representing your client, are you also supposed to take into account that society needs taxes, right, to keep the system generated, so that you can't be over the top in terms of your representation of your client. So that's a rhetorical question or statement on my part, meaning it's very hard sometimes to weigh the interest of your client versus those of what duty, if any, do you owe to the system. So the authors here, okay, Michael Lang and Linda Geller, just raise that without resolving it, because it's one of those things that can't be resolved, but just calling it to your attention that there are these duties and that there's something to consider. All right, so the introduction is not much here. Again, nothing that you're going to see on an exam, but just some things to think about. So then let's get into chapter 1 and talk about what we need to in terms of how we as a profession are regulated. And we're going to talk periodically about lawyers versus accountants. For exam purposes, largely the questions will be geared towards what are your responsibilities as an accountant, but periodically or sprinkled throughout the exam, I might ask what is the difference between a lawyer's responsibility versus an accountant's responsibility, because you will see by juxtapositioning those different roles that there are sometimes different standards and different rules that apply to one versus the other. And one of the biggest, I'll just give you some more foreshadowing, is that when it comes to advertising, lawyers are much more restrictive in how they can advertise and how they can solicit business. In contrast, accountants do not have that same limitation, all right? So that's a very big difference between attorneys and accountants in the sphere of advertising. All right, state regulation, I'm on page 7. And the authors make this point, I'll make it again in chapter 6, even towards the end, is that violating ethical rules, often the Bar Association or the AICPA or the state licensing board will not chase you. I mean, sometimes they will, if it's egregious enough, but they don't have the resources to chase all the violations. But if you run afoul of these ethical rules, bear in mind that often in malpractice cases, and I've been an expert witness now probably in about 20 plus malpractice cases. It's a lot easier to be an expert witness than it is to be being sued yourself. But one of the things as an expert witness typically I will do, and I'm not alone, is you will point out in that litigation that the practitioner violated his or her ethical rules, and that being the case, they caused malpractice. And what I want to say is juries or judges may not understand some of the details of what the technical aspects of what was being violated, okay, from a tax perspective. But many people on the jury or judges, they don't understand tax, but they understand ethical rules, or the flavor of the ethical rules. So if you violate these ethical rules, it will potentially color a jury's opinion of who you are as a practitioner, or the judge's opinion. So I just want to point out that if you think, gee, these rules, first of all, they do get enforced. I mean, they do get enforced. And when they get enforced, in yesteryear, when I started practice, someone who violated them could keep it on the down low, meaning you violated, maybe you got to censor someone, the State Bar Association or the AICPA was gonna censor you and, say that you were a bad practitioner and publish it like in their newsletter, okay? But it quickly died because the newsletter wasn't read by everyone, or it got read, but then it forgotten about. The world has changed, right? What happens now if you get censored or if you get suspended? Well, it gets published. Well, it doesn't just get published on paper, right? It's published and it's usually posted on the internet. And then what happens when your clients who are your clients Google you? Well, they come across you as being someone who is suspended for some sort of ethical violation. Do you think that's the person they want to sign up with? So just be careful, because again, in yesteryear, I can tell you that people who suffered because they violated these rules, and were censored or suspended, yes, it was painful, but they could easily recoup themselves. Now, you've got the market cane, and that market cane is not going away anytime soon, right? So just, it's a whole different level that you gotta be cognizant of. So, the authors just give us an introduction, and what is the mainstay of how accountants are supposed to be kept in line? What is the Bible? Say it loud. Circular 230 is certainly one Bible, right? That we're all supposed to adhere to Circular 230, right? But, and by the way, the authors, very kind of them, and you guys do it your own way, I have it my way. I have my stickies here. My stickies, I have marked each appendix towards the back, and Circular 230 is right here in front. All right, so you should make it easy, because we will make lots of references to Circular 230. That is certainly, a set of rules that, from a federal level, we're still supposed to comply with. But more specifically to accountants. SSTS, right,
Yes.
Peter? Do you know where it is in our book?
Yes, it is on page 8.
But it's also on page 365.
Oh, the actual.
The actual Appendix C. So if you want to just open that up for a second. The SSTS, Statements on Standards for Tax Services. Everyone see that? So, there's different statements. One pertains to tax return positions. You can look at it, when you look at page 365, what do you do if there's errors on there's returns, errors on the returns, a whole list of rules here. And this is what you're supposed to adhere to insofar as tax return preparation is concerned. And if you violate it, then you risk censure, suspension, or even in egregious cases, revocation of your license. Right, so bear in mind that you have the federal level, Circular 230, state level, you have the New Jersey AICPA and the state licensing board. Problem 1-1 states, preparation of an income tax return does not constitute the practice of law in the sense that non-lawyers may lawfully prepare returns. If an attorney prepares tax returns for clients, should her services be subject to her state's professional conduct rules? Okay, so the statement here is, if tax return preparation can be done by anyone, you don't need to be specially licensed. If you do prepare returns as a CPA, or you do prepare returns as a lawyer, does that subject you to ethical rules that we're referring to? Peter, you're nodding.
Say yes.
You're yes. Okay, that's correct. In other words, if you're going to charge fees as a professional, right, you're holding yourself out as a professional. The fact that it could be done by someone out of his or her garage with no license and no ethical duties does not alleviate you as a professional from Circular 230 or the AICPA rules or the state licensing board rules. So the point is that will never be a reason that you can get away with potentially violating your rules. Right? Problem 1-2. Many tax attorneys who are also CPAs hold themselves out as dual professionals and whose practices consist of providing both legal and accounting services. The ethical rules of each profession differ, for example, as to referrals or as to solicitation of clients. Which professional rules must the individual follow? May such a practitioner choose to follow a rule that is least restrictive? Why or why not? So, some of you may work in offices where the people you work with are lawyers and accountants. I've seen this before, where they have I'll call it an upstairs office and a downstairs office, where they have the law office upstairs or the accounting office upstairs and the law office downstairs, or vice versa. Which rules do you have to adhere to? First of all, is there a risk in that? And in this case, Ping, you're saying yes, right? What's the risk, Ping?
Because if you're both lawyer and accountant, and you have to hold both ethic.
You're the generally the higher one, okay?
Yes.
And I've had just, this is not me, but a friend of mine, truly a friend of mine, he did some work, legal work, and then had his accounting firm, which was different letterhead, but at the same address, do other work. And then there was a problem, there was a flaw in the work that was done. And generally, the lawyers and accountants who do this have two separate malpractice policies, right? They have a malpractice policy for the law work, they have a malpractice policy for their accounting work. Well, when there is a flaw, what do you think happens in this case? I mean, I'm not going to say it's universal, but what do most insurance companies like to say? Right, no, you're not covered, right? That's for some reason, you're not covered. And in this case, what ended up happening is the accounting firm said, look, that's a legal issue you were handling, we don't cover that. And then the law malpractice insurance company said, we don't cover this, this is an accounting issue. So each one took the position the other, and you might say, well, that's a fight they should have, but in the meantime, my friend had to endure the notion that he might not have any coverage because each one was saying that the other one was supposed to be responsible, or so it can be tough. So you got to be careful if you have lawyers and accountants in your office. Are they practicing law? Are they practicing accounting? And what are your liability exposure there? All right. All right. And as Ping pointed out, when in doubt, you should always file or adhere to, I should say, the highest standard and not the lower standard between the two. And there is obviously a fine line, particularly in tax, between accounting and law, right? Because when you look at the Internal Revenue Code, what is it? And the regulations, that's law, right? That's, Congress has enacted Title 26. So every accountant is practicing some facet of law, right? And every lawyer who deals with numbers, right, and helps prepare tax returns is participating in the sphere of accounting. So there's a tremendous overlap between the professions, at least insofar as tax law is concerned. The relationship between tax lawyers and the IRS, again, this section, beginning on page 9, talks about the tension between tax lawyers and the IRS and what the responsibilities are of tax lawyers to the IRS. And this ABA opinion, now 50 years old, is supposed to express, this is ABA Formal Opinion 314, supposed to express what is the position of, what should be the position, lawyer's position to the IRS. And it's something that we saw a glimpse of being in the introduction, a glimpse of it being semi-adversarial, not completely adversarial, semi-adversarial. So if you look on page 10, there's a statement, first paragraph, Internal Revenue Service is neither a true tribunal nor even a quasi-judicial institution. So it's just pointing out that the IRS has its own agenda, and it's not a disinterested party. I will point out on page 11, the last full paragraph that starts off with similarly. Okay? Talks about, on the third line down there, that you can take a position as long as there's a reasonable basis. I just want to call to your attention that there is no longer, you cannot, whether you're an accountant or an attorney, you cannot just take a tax return position that's quote unquote a reasonable basis. What is the standard in the year 2019 that you're supposed to adhere to?
More likely than not.
That's with respect to what, B?
Gosh,
What is the standard? What is the most applicable standard? I'm not saying you're wrong, that's in a certain context. What is the go-to standard that we as practitioners are supposed to adhere to?
Due diligence?
Well, we're always supposed to have due diligence, but the standard for tax return, with respect to our clients, what are we supposed to, and this is something I want to drill in you because it's really, really important. What standard are we all supposed to adhere to Andrew,
Reasonable basis.
no, reasonable basis will get you sued. Possibly get you sued. What is the fight? If I say, we can play a word game here. If I give you 2 letters, will you fill in the blanks? S.A.?
substantial.
That's what I want to
authority,
hear.
yeah.
Substantial authority. Okay? That is the standard. Okay? We're going to talk, but that, to take a return position, generally you're supposed to have substantial authority. And we'll talk about what that means in more depth, but it's just, my point is this was written 50 years ago. Used to be, the standards have been raised. Used to be reasonable basis. Can you still, at any point, use reasonable basis? Right? Has that been vanquished to obscurity? Can you ever just have a reasonable basis? And I'll answer the question, yes, but you need to tell me when. But
If there is no substantial authority?
well, no, because what do you need to do in addition to having a reasonable basis?
An explanation.
And
You have to back it up with some sort of
you have to
evidence. something like that.
Disclose.
Disclose.
Disclose. And one of my favorite forms. What is a disclosure form? This is one of my favorite forms. Everyone has a favorite form in this room? If you don't, maybe I'm going to make this one your favorite too. Form 8275, disclosure form, Form 8275. So, you have, or I have it, Dad mentioned one, right? That's different. We have a pretty low standard where you have reasonable basis plus disclosure. Then we have a higher substantial authority. And then to get to V's point, more likely than not standard. When do you need a more likely than not? In what context? You need it for tax shelters. Tax shelters. And we'll talk more about these. Tax shelters. So this should become ingrained in your mind for this class and outside this class for practice, because these are important standards that come up all the time. Why do I personally, why might you think I love Form 8275?
It's protection.
Why might you love it too? What you were gonna say?
It protects you, I guess.
Protects you, but in what way? Think as a practitioner. How does it protect you as a
If
practitioner?
you asked all the right interview questions.
Say again, Peter?
If you asked all the correct interview questions to support all of the income or I guess expenses that the taxpayer may put.
I mean, hopefully you have your questionnaire and you ask all the appropriate questions, but I'm getting to the point, or go ahead, Trevor.
Would it be more efficient to have a reasonable basis plus that form than getting substantial?
You may not be able to get substantial authority, but what do your clients, when you tell them about disclosure, what do most of your clients say? Yes or no? Hey, what do you say?
The clients would not want to disclose, right?
Most clients don't, right? They're scared. They think this makes them like having an X on their back, right? If they make disclosure. But, if you don't mind me saying, what is your most likely chance of you being sued, guys? What is the greatest likelihood of malpractice? What will your clients have that they'll say, not my issue, your issue? Your clients get hit with penalties, right? Everyone agree? And if your client gets penalized, what does your client say? It's your fault, right? Your fault. You pay the penalty. Those penalties, which we'll get into soon, can be steep, right? But by you saying in your letter to your client, look, you want to take this return position, I don't think there's substantial authority, you should disclose it. In my mind, that's a pretty good way to protect yourself from penalties or malpractice. Why? Because the client says, no, I don't want to disclose it, and they subsequently get hit with a penalty. Hey, you told them that had they disclosed it, they would have been safeguarded from penalties. That's a pretty good way to shelter yourself. So I consider it very important to document, and often will with clients, to take a position, because they don't get to substantial authority. There is some basis for their, but to make disclosure. Now, also I want to share with you that on several occasions, I have filed, I don't just use it tactically to avoid malpractice suits, although parenthetically I do, but I have submitted. Has anyone here ever submitted a disclosure form? No one. Guys, come on. I have, and none of my clients have ever been audited as a result. In other words, we took positions, and I think they were sound positions, so maybe they were, the IRS looked the other way. But every one of those disclosure positions met with success. So I don't know if necessarily, at least in my experience, that it will be perceived as please audit me kind of thing. So just letting you know that that's an option. And it could be used, again, as an effective means for your client to sleep at night, and it could be used as an effective means for you to sleep at night. Right? So everyone's with me that there's these different standards depending on, and we're going to talk much more in depth about this, but these are things that you really have to focus on. I just want to call to your attention in the context of this ruling, a reasonable basis is no longer, it's a 50-year-old opinion. That facet of it is no longer accurate. Okay? All right, so let's pause for a moment and look at page 13 and the two problems here, because they're not really problems, they're, to me at least, they're more expressions. So on page 13, problem 1-3 says, is the filing of a tax return an adversarial process? A good question, is it an adversarial process? And you will see, and I have two circles, because the authors here have two different positions. This is, and I'm not sure if they're reconcilable. If it is, then a lawyer/accountant arguably acts as an advocate in rendering advice in connection with positions taken on a return. As an advocate, ethics rules permit a lawyer/accountant to advise his client not to volunteer information to the IRS, and the lawyer herself is not obligated to disclose weakness in her client's position. Indeed, a lawyer in an advocacy role is prohibited, with narrow exceptions, from disclosing client confidences without the express permission of the client. So, just to make this point, if there's an advocacy position, it takes on one flavor. Conversely, it says, on the other hand, advice rendered to a client in connection with a return preparation may be characterized as merely helping a client satisfy the legal obligation to file a tax return. In advising a taxpayer how to comply with the law, duties as an advocate arguably do not come into play at all. Okay? But see Code Section 6694, which we're going to talk about in probably next class in depth, which imposes a steep penalty on tax return preparers who advise return positions that do not satisfy specific statutory standards. All right, so there's not a clear answer, obviously, when you look at problem 1-3 about how to resolve whether or not tax return preparation is in advocacy or not. So it would not lend itself to a multiple choice question kind of guy. It's one of these that could be answered either way. I will share with you Linda Geller, one of the co-authors of this book, truly has immersed herself in a lot of practice. So I like this textbook a lot, only because I know Michael is truly an academic. Linda is much more someone who has practiced a lot. And when you read through these questions, you can see, I think they really get to the heart of what some of the things we do in this room. So it's not someone just taking an academic point of view. Linda, I know, brings to the table a lot of practical experience. And by the way, if you guys come up with questions in the upcoming weeks about something in the textbook and you want me to run it by Michael or Linda or both of them, just shoot me an email or ask me during class, and I'll, the last several classes, students have had questions and I've reached out to them, and they're very responsive, so happy to reach out to them again. Problem 1-4, tax practice differs from other practice areas because the client's adversary is usually the government. Does this distinction imply that attorneys engaging in tax practice or should be subject to different standards than attorneys who practice in other areas of the law? On the one hand, it can be argued that ethical issues encountered in dealing with the government are largely the same as those presented in dealing with any adversary, okay? So, one hand, all the litigation that goes on with the IRS is just like any other litigant. But, conversely, on the other hand, tax system predicated on voluntary compliance and self-assessment may be more properly viewed as imposing duties on the practitioner to both the client and the tax system. The introduction to this text posits that tax lawyers / tax accountants are indeed subject to special duties to the nation's revenue raising process and to the government agents that administer it, that is the IRS. And what I will call, I have a case that I'm working with, and you're going to meet Bob Stern, who's going to lecture on criminal, is that when people litigate with the IRS, they are sensitive, in my experience, they are sensitive to the fact that chances are, when you do litigation, 99% of the time, take the state of New Jersey, you're not going to litigate that. There's thousands and thousands of attorneys, and you're not going to litigate with the same attorney again, right? But when it comes to IRS litigation, the people at the Justice Department and the people at the IRS, if you do a lot of litigation, you're going to want to maintain some sort of rapport with the people you're litigating because you're going to do it again and again and again. So it's kind of an interesting dynamic because my experience is that you don't go for the jugular often when you're doing this kind of litigation. In fact, I got a call from a client just yesterday who said, well, do you think Bob is going to give 100% here because he's friends with the guy who's at the Department of Justice? I said, he's going to give you 100%, but it's all I'm calling to your attention is that these kind of things, when the litigation unfolds, there's a little bit more what's the word I can never pronounce? Congeniality between and among the people, because they know that they're going to have to coexist on a going forward basis. So it's perhaps not as rough as other forms of litigation. All right. So anyway, guys, question 1-3, 1-4, they're more of rhetorical questions than real questions because there are no clear answers here in either of these. Jurisdictional questions, okay, which we're going to deal much more in chapter 5. Okay. As an accountant, can you practice in any state, guys? No? What's your why, Peter?
Most states are regulated. Be registered in that state.
Okay,
when
but
it comes
can you,
to state, but
right.
federally you can.
So Peter, can you register in any state? Right. So you can't practice, but you can register in any state. And most of you, let me just ask you, and Brian, Trevor, your firm, you guys do a number of state income tax returns, right? Are you registered to practice in those states, or do you just do those returns?
I'm not registered in those states, but we still do them.
That's my experience. Peter?
Same.
All right, so, it's always interesting when you do that. You have software programs presumably, and Peter, where do you practice? Your own firm?
In Pakistan?
Okay. But you have software packages for those various
50
states.
states.
Right.
And Puerto Rico.
And Puerto Rico. Is that when you do your practice, it's how do I say, a bit more when you're doing state returns. Do you guys get a little bit unnerved by it because you're not used to the laws of those particular states? And if there's a flaw, my opinion is you're opening yourself up to malpractice based in those particular states. So, as painful as malpractice suit is, if it's in New Jersey, picture if it's in Idaho, and you've got to go out to Idaho, be deposed and things like that. So, just be forewarned that.
We just did a lot of research. My daughter, fortunately, she went to Swamin, and she went to school with a football player who made it to the NFL. Not for long, but so she called in her friends, and when you play for the NFL, you get a W-2 for every state you play.
Right, absolutely.
So that there was a question that came out. My daughter spent hours doing research as much as we could to do all those states properly.
Right.
But you're right, it still doesn't, it can still open you up.
It opens you up because there's some
But
nuances.
that wasn't like normal practice, that was the exception because I was her friend and he was
Right.
really not getting good service in Queens where he was from. So we got lucky with that. We did a very good job.
The tough thing I've had some football players as clients, but the pressures they're under every year to perform and perform, it's pretty intense thing. You were gonna say?
CPA, they do have a mobile license, so they can, if you apply for the mobile license, you can go to different state. So the mobile license.
I'm not familiar with the mobile license, so anyone else have is that thing, you apply for a mobile license, anyone else?
Yes, because like mine is at New Jersey, and then if you have mobile license, which is, you can go to different state to do the business. I believe right now they do have this one.
Anyone else? So you're registered as a mobile CPA?
Yeah, they do.
And who did you register with?
I'm not sure because I did not do this one because for ethic, every state like CPA, they do have an ethic education. They say you do have this. So I can send you a link.
Yeah, send me a link, I'm just curious. All right, the point is, as a CPA, you have pretty much free reign, one, to perform tax services in other states, with the caveat that many states would prefer that you register, but many people don't. Is that a fair statement on my part, Peter?
Yep.
Did you register, by the way? No. Lawyers, and I can say this, is to my knowledge, most CPAs, or to my knowledge, they're not going to be challenged even if they don't register. They're not going to be threatened with possible suspension or stripped of their license, whereas lawyers who practice in multiple states really have a problem. You're supposed to be licensed in a particular state before you practice in it. So again, by way of contrast or juxtaposition, very different standards that apply to accountants versus lawyers. All right? So multi-jurisdictional practice, one has to be very, very careful about with respect to lawyers. So if you have a lawyer, anyone in this room, who you're working side by side, and they're licensed in Pennsylvania, and they just want to do a deal in New Jersey, and they're using you guys are the lawyer accountant team, get nervous, because lawyers, how do I say this? Many people are very hungry for business, right? And sometimes that being hungry for business intoxicates them to making mistakes. And if you don't want to be part of their mistake where you have a lawyer in Philadelphia who comes across the border to do a deal with you, and there's something wrong, and you're working with that person, that can be problematic if they're not licensed. All right, so, again, very different rules. So let's look at the problems. Here, 1-5. Lawyer has been licensed to practice in DC, and we're gonna see more of this in chapter 5. For many years and has a federal tax practice there for most of the time. He's got tired of the Beltway rat race and has decided to move to pristine Bend, Oregon, and open a practice limited representing clients in a federal tax matters such as federal income, corporate, and estate tax filing. So only doing federal, not Oregon kind of work. Can the lawyer do this without taking and passing the Oregon exam? Now, there's a reference here to the model rules. And the model rules, by the way, let me just say this, that you can, anyone here, can go online and look up these model rules. I'm just gonna distribute, this is model rule 1.3. If you type into Google whatever the rule is, you can get the rule, and then the rule itself, the lawyer shall act with reasonable diligence and promptness in representing a client. Okay, you have the general broad rule, but the comments that follow the rule often are more useful and enlightening than just the rule itself. So here's 3 here.
I saw problem 1.5 more as a question for a tax attorney versus a CPA.
Say again, Peter?
But I read 1.5 as the problem more for the tax attorney versus a CPA.
What is 1.5?
One that we're discussing on the problem 1.5.
Oh, okay.
I didn't see how that question could really apply
To-
to tax accountant.
No, it doesn't. This rule is strictly limited to lawyers, okay? Question 1.5 is definitely just limited to lawyers. Can you just practice federal law if you move to this other state? In other words, this attorney is not practicing anything to do with state of Oregon law. And any notion of what you can do here?
I would assume yes.
I think it's yes,
I don't
yeah.
know. The IRS can see you in any given office, I assume you have to.
Well, the IRS can see you at any office, they don't care.
State.
The agency doesn't care. Just so you know, the authors, and we're gonna be talking about this, it's mentioned in problem 1.6. If you look, you see that Sperry case, Sperry v. Florida? That's a Supreme Court case in 1963. Everyone see that reference? That Supreme Court case, Sperry, and we're gonna look at that case in chapter 5, says that if your practice is limited, Peter, as you were alluding to a federal issues, not state, that would be permissible, okay? So if you are limited to federal, not state, that would be permissible. So the only thing that I will add here is New Jersey has an opinion. It's New Jersey Unauthorized Practice of Law Opinion 44. I'll repeat, New Jersey Unauthorized Practice of Law Opinion 44 says that you can come to New Jersey and practice on federal matters, but this opinion says that you can't have an office in New Jersey. So I don't know if anyone has ever challenged this, but it simply says, essentially, okay, we'll respect the fact this is federal law, but we just don't want you to have an office here because you're not licensed here. All right, so, for your notes, problem 1-5, my gut is you can do this as long as, again, you're limited. Some states may have further restrictions that you can do it, but you can't have a physical office, but, again, I don't know if that's ever been upheld. Problem 1-6, lawyer is a tax lawyer at a Seattle firm. Lawyer represents a large corporation that is under audit. The revenue agent and lawyer agree to send certain issues to the IRS appeals, and the case is assigned to an IRS appeals office in San Francisco. Lawyer is unable to resolve the matter through email and telephone conversation. It becomes necessary to hold a conference. Lawyer travels to San Francisco for conference. Would California be justified in asserting the lawyer is engaged in unauthorized practice of law in California? And what do we know is that the takeaway from 1.5, the takeaway is similar to 1.6, meaning that this should be permissible. That, as Peter was saying before, that the IRS offices, and some of you may have IRS issues where instead of resolving them in New Jersey, some of you maybe have had to go to New York, right? And as an accountant, that's not an issue. As an attorney, the point of this problem is to say it's not an issue either. Whether you're an attorney or an accountant, you can go to other states and you're not going to be engaged in the unauthorized practice of law. How about lawyer is a tax associate in a Cincinnati firm, is licensed to practice in Ohio. She often works in her home in Kentucky on weekends. In which state is the lawyer practicing law on the weekends? Now, there's a reference here to this Zelensky case. If you practice, and again, shoot.
When they say practicing law, I interpret that as physically showing up to court, being part of the litigation. I don't see it as sitting home doing research or preparing for a case. Is there a difference, or am I correct in assuming that? Or is there a set standard saying that if you are working on a case from home, it's still considered practicing law?
When we talk about the practice of law in Chapter 5, you raise a good point. What is the practice of law? Does the practice of law, if you're doing tax research, when we do have our class on Wednesday, is that practice of law? You guys engaged in the unauthorized practice of law because you're doing tax research, which is illegal. So I will hold off on your question, save it for Chapter 5. I know Ed Zelensky. This is the guy who brought this case. His ego cannot fit in this building, okay, just by way of background, all right? He's a very bright guy. He's a real expert in state law issues, okay? So what he teaches at Cardozo Law School, and Zelensky was, just by way of background, coming to Cardozo, New York City. He lives in Connecticut. He would come to school for 3 days, and then he would practice. When I say practice, he would do work in his Connecticut home for 2 days. And he wanted to take the position that 2/5 of his income should not be taxed in New York because he was performing his duties in Connecticut, and only 60% of the time was he in New York. And the question was, should 100% be taxable in New York, or should only 60% of his income be taxable in New York? And what did the court in New York hold? What do you guys speculate? 100% or 60%?
100%.
Okay, and we were all a little cynical because the judges who are adjudicating the case, who pays their salary? New York. It was funded by the revenue. So you might say they might bring their own biases, but what was the rationale to say 100%? Because picture, if you will, be truly, I'm oversimplifying the facts a bit, but he truly spent 60% in New York, 40% in Connecticut. On what basis did, say again? Well, remember, he was a resident of Connecticut, he lived in Connecticut.
But he mostly spent time in New York.
He spent more time, but that, you know, a lot of people do, by spending work time doesn't make you a resident, because that's a domicile issue.
Well, we get that a lot, for clients that are in a similar situation where, you know, they live, you know, work in New Jersey, New York, they either have a satellite office or they work from home, and you have to determine what days, especially for New York, 19205, you have to determine, you know, the percentage so you can reduce the taxable income for New York State. So I see that what you're referencing, because I see that a lot.
He did not prevail. I don't know.
Yeah, I'm just saying that I see that a lot.
Well, the difference, I think, in part, New York took the position that it was for his convenience that he worked from home, not for the convenience of the employer. So that's the one thing. Two, when he did his work from home, he did his work and his publications, everything was really oriented around Cardozo Law School, where he teaches. So that was like, Cardozo was what was allowing him to generate his income, because he was responding to students, he was publishing his articles. The 2 days that he spent in Connecticut were days that were really focused on improving his stature in or at Cardozo Law School. So what that meant was that Cardozo, which was located obviously in the heart of New York and New York City, was the impetus behind his success. Therefore, it had no problem saying 100% was taxable. So he
But
doesn't.
he had a contract with an employer though, however, part of the contract was he worked from home 2 days.
Okay, but that's if he had a contract with a different employer.
Right,
All right,
or a different scenario.
Different scenario. So in response to problem 1-7, I think it's fair to say that you're truly practicing, right, in Ohio, and the fact that you're doing it weekends in Connecticut or Kentucky, I should say, it is immaterial. And by the way, this gets to another logistical issue that the court raised as well, is that how hard would it be for the court or the state of New York to monitor people like Zelensky to figure out what kind of work they were doing during the weekdays or on weekends, and trying to bifurcate income, because it gets a little bit crazy. Taxpayers are going to come up with their own percentages, and then for the state of New York to try to figure out what percentage of work was being done at each location would be near to impossible. So from an administrative perspective, that too thwarted Zelensky's position. So in problem 1-7, I think it's a fair statement to say the fact that you're doing work for your own convenience, not for the convenience of the employer in a different state, doesn't mean that you're practicing law in that other state. And Peter, this gets to your point, the fact you're doing work, reading, writing memos, is that really the practice of law? So that's another question. Again, we're going to look in chapter 5, is that practice of law? All right, so these are just teasers for what's coming in chapter 5. Let's talk about Circular 230, and I think the author should have given you a copy of Circular 230, so I think they should have. So here's my opportunity to give you, when I say Circular 230, Circular 230 are the regulations for Title 31, Section 330. I'm sorry. Got it. Does anyone know why we have Circular 230, or where the origin of you're gonna see this when we talk about two court decisions, two important ones are Loving and Ridgely. But what is the origin of this statute? What are you looking at? Let me just remind people. On the bottom of page 14, there's a reference there to a statute, Title 31, USC 330. That's what you're looking at right here, everyone. And this is the statute. Remember, what is Circular 230, guys? Some people get lost in this. That is the regulations promulgated under the statute. And what does this statute say? Let's look at it together. Subject to Section 500 of Title V, the Secretary of State may regulate the practice of representatives of persons before the Treasury Department, and before admitting a representative practice, require the representative demonstrate good character, good reputation, necessary qualifications to enable the representative to provide persons with valuable service, and competency to advise and assist persons presenting their cases. Okay? And then it says, it enables the treasurer to suspend or disbar from practice or censor any representative who's incompetent, disreputable, violates regulations prescribed under this section, or with an intent to defraud willfully and knowingly misleads or threatens the person being represented or a prospective person to be represented. Goes from there. Why did this, and from this very, very broad language, Circular 230 fills in the flesh. Okay, so we have this very broad statute. Why did this come into being? Why did Congress authorize the Secretary of Treasury to limit the practice?
I think it's because prior to that, there was no true regulation of tax practices.
Do you know when this came into being? What year?
20s.
Came into being right after the Civil War. Okay. Why? Because after the Civil War, many people were looking for reparations because the armies had commandeered, in particular, horses, okay, during the Civil War. And they were looking to be compensated for what they had given the government. And as a result, Congress said, we want to make sure that if you have people coming to what was the equivalent of the IRS then, the Secretary, and demanding money, right, for their horses, that they were good people, okay, that not just Joe Sixpack would come knocking on the door and say, hey, we gave you 10 horses, we need to be compensated, that only, as you read the statute, reputable people would come and represent other, the people who had their horses taken. And I'm not kidding. When you look at the history of this statute, it all sprung from the Civil War and making sure that the right people came and did the right things when they were looking to get compensation on behalf of their clients. So that from the Civil War came the statute. From this statute comes Circular 230, right? So a little history lesson. And there's obviously a lot of value, obviously, in people's horses. So anyway, so you guys now have the statute. Again, like many statutes, those who have looked at the Internal Revenue Code, right, you know that you have, the Internal Revenue Code has this section like 721 that deals with partnership contributions that goes for one paragraph, and then the regulations promulgated under 721 go for 4 or 5 pages, single space. Similarly, you have a very short statute here. It's not in Title 26, which deals with the Internal Revenue Code. Here instead, Title 31, about what the Secretary of Treasury can do. But then we have Circular 230, which you see in Appendix A, extends 15, 20 pages, single space. Okay, so on page 15, practicing before the IRS, and Circular 230 and our authors point out that 5 professionals are permitted to represent taxpayers before the IRS. Attorneys and CPAs. We have enrolled agents. We have enrolled actuaries and enrolled retirement plan agents. Okay, so those are the people who are permitted to practice before the IRS. Now, bear in mind, in 2011, the Treasury Department tried to recraft Circular 230 to essentially broaden its application to anyone who prepared tax returns, right? Because who are the gatekeepers to our nation's revenue system? Tax return preparers, right? I think, you guys can Google this on me, I think, what percentage of tax returns prepared by a paid professional? What percentage?
Yes. 85?
What percentage?
85?
I think it's around 60%. I don't think it's as high as 85%. But needless to say,
Yeah, 60.
is that the percentage, Jay?
Yeah.
B?
Yeah.
You just Googled it?
I just Googled. The IRS says that.
Okay, it's about 60%, right? All right. Phew. Almost lost credibility up here. About 60%. All right, I vaguely remember that. But that's an important percentage, because you would imagine perhaps 20–30% are people who have low income and they can't afford to pay a professional. So a lot of people do have paid professional help. And needless to say, the lobbyists for Intuit and other professionals want to keep they have a very robust revenue flow from doing this, and we as professionals too like to keep our turf. So there's different. Well, it's going to be interesting to see now that there is now most people, or when I say that, a larger percentage is now going to opt to use the standard deduction as opposed to itemizing. And you may see, on one hand, fewer people coming to your offices because they're just going to take the standard deduction. On the other hand, there are going to be a bigger percentage of what kind of people utilizing your services. What code section are they going to try to capitalize upon?
199.
Yeah, 199A. All right, so there is going to be 199A, for those who don't know the code by heart, deals with qualified business deductions, right? Where you can get up to 20% of your business income, the deduction if you meet certain qualifications. So that's the Revenue Employment Act that was offered by the 2017 legislation. Go ahead.
I have one question. For the paid taxpayer, nowadays they do use, a lot of people use the online, software through the package. Is that one of those group of people? They use online service.
What I buy TurboTax.
Yes.
And I get a software package.
Yes.
And your question is what?
My question is, those one people use software, software, and then is there kind as a paid tax prepare?
No,
Or
no.
just go online because they use online service, they file director.
But if you're paying for software, that's not considered you're not paying, it's not a paid preparer. You're paying for the software. Did
But
I
they-
understand your question?
Yeah, if they use online service, which is they file through the, the service, those tax, prepare software vendor. So they have a PIN number wherever they use.
Who uses the PTIN number?
PTIN number, yes, because when you file from the TurboTax online.
Because you're paying, in my experience, and you guys can correct me if I'm wrong, if you've seen something different. My experience is you only have to use your PTIN if you prepared the return. But if individually, the taxpayer is preparing his or her own return, there's no paid professional.
I think what I've seen, I'm not sure if I understand correctly, but what I've seen is why I guess we had, the IRS try and make every tax preparer register, and not that we love it, but I think what I've seen is tax preparers, paid tax preparers, that lie to their clients, and they sit there and they do whatever, and it prints out from TurboTax as if the individual is doing it, but it's not. So they basically
They get a fee.
Right, they get a fee, they don't tell the client, they don't sign off on it, and when it's printed out, it'll say self-prepared. I've seen clients come in like that, and with a folder, labeled from wherever they came from, a lot of travel agencies, and then they say, oh no, I didn't do it, my accountant did it. But clearly there's no PTIN, there's no registration, so I think that's what's happening, that a lot of places that are saying they're tax preparers, they're using TurboTax and misleading the client. In my case, it's been more Spanish-speaking clients that don't really understand most of it, and then the client comes out assuming that, oh, no, I didn't do it, the tax preparer did. I don't know if that's what you mean, but I've seen a lot of that.
Is that what you mean?
Because for those third-party vendor, sometimes they say if your income below 50, and then you get a free tax return, and then if you have income above 50.
Let's pause. There are, it's called free file.
Yes.
And TurboTax and others are required to offer so-called free file, which is misleading. I can get into all stories about free file, is because embedded in free file, they try to entice you to go off free file. So there's a lot of problems with that. But free file is for low-income taxpayers, and they have an opportunity to use TurboTax for free. Now your question is what? Now there is no PTIN on that because, and the software companies never, ever use or supply taxpayers with a PTIN.
But they direct send e-file, individual e-file to the IRS. Sometimes they do this way.
Who's they?
The vendor they send out,
See, anytime you use the word vendor, to me that's an important characterization on your part, because you're not preparing your return. The vendor is supplying you with a platform to prepare your return, but that is not, they're not required to give you a PTIN.
Okay.
That's why it says self-prepared every time you come out, say self-prepared.
Right. Right. So, just to let you know. All right, so PTINs. Hopefully everyone got their PTIN this year for those who are preparing tax returns. I just got mine, but before the shutdown. They're still operational, right? Okay. And the only thing I will call to your attention, so let me just say, and we're gonna look more in depth in this in next class, is that the IRS wanted, or I should say the Treasury Department, wanted all paid preparers be under the scope of Circular 230. There are two court decisions, the Loving decision and the Ridgely decision, that said this regulation was struck down, that paid preparers do not have to or are not subject to the rules of Circular 230. All right, so having said that, at least for the time being, all paid preparers still need to get a PTIN number. All tax return preparers need to secure a PTIN number in yesteryear, the IRS required a fee to be paid. Okay? This year and last year, they did not. If you look at footnote 5, there's a case at the very last line, Steele v. United States. I Googled this yesterday. This case still has not been resolved. So right now, the case, there is a case, a district court case, that said that no fee can be charged, but that's being appealed by the IRS. So the jury is still out on that one. So for the time being, you gotta secure a PTIN number, and for the time being, there is no fee associated with securing that number. Why did the IRS want return preparers to have a PTIN number? Well, by having a PTIN number, the IRS is in a position to monitor tax return preparers and just make sure that if there's a bad apple, they can trace it down to that bad apple. So I will call to your attention, it's worth reading the second full paragraph, short paragraph, the last full paragraph on page 16. Unless until Congress acts, preparing and filing tax returns for clients do not, I have the word not, constitute practice before the IRS, and therefore are not subject to the provisions of Circular 230 or oversight by OPR, stands for Office of Professional Responsibilities. So you know, OPR stands for Office of Professional Responsibilities. At least when those services are performed by persons who are not lawyers, CPAs, or enrolled agents. So it concludes that thus a person needs no particular training, professional credential to prepare tax returns for others. Let's do these problems on page 17 and then we'll take a break, okay? So give me a few more minutes and then we'll take a break. Problem 1-8. A friend of yours knows that you took a lot of tax courses at law school or at Rutgers accounting program. At some point before you're admitted to the bar or you have your CPA license, your friend asked you to prepare her tax return for 2018. Can you do it?
I say yes.
Say yes. Anyone?
Not subject to
Don't sign your name.
Right. Anyone. You don't have to have any tax courses. You can go to cooking school, okay, and prepare people's tax returns. That's, again, that's what the IRS was in the Treasury Department, why they wanted the scope to be increased, but that was shot down, and whatever it's worth, Congress appears to have no appetite at the moment. To me, it's a no-brainer. I'll put my biases out there that Congress should be more proactive into trying to regulate tax return preparers than it is. Our country's, we need good tax return preparers. So anyway, in response to problem 1-8, everyone, I think you guys universally say, no problem, right? Problem 1-9. You're still not admitted with an exclamation point. A friend receives a letter from the IRS concerning an income tax return that she filed last year. She asked you to help, she asked for your help and advice. At this point, it looks like you will have to write a letter to the IRS clarifying a few facts. Can you write the letter on your friend's behalf? I mean, implicit in that is this the practice before the IRS?
Yes, it is. You could, you have to be at least one of the 5 professions.
Let's just look together, just so we get, look at 10.2, this is on page 322. 22, it says, practice before the Internal Revenue Service comprehends all matters concerned with a presentation to the IRS or any of its officers or employees relating to a taxpayer's rights, privileges, or liabilities under the laws or regulations administered by the IRS. Such presentations include, but are not limited to, here we go, guys, preparing documents, filing documents, corresponding, right? Sound familiar? And communicating with the IRS, rendering written advice with respect to any entity, transaction, plan or arrangement, or any other plan or arrangement having a potential for tax avoidance or evasion, representing a client at conferences, hearings, and meetings. So you can see it's quite broad, right? Any direct contact with the IRS could constitute the practice of law, and just because the government was scared of horse scammers, right? Back in 1867 or whatever, they're scared that people like this person might be out to scam the IRS, so therefore we do have to worry about the application of Circular 230 and really should not be practicing before the IRS, right? So in problem 1-9, this person should not be doing this. Okay? And it's certainly, if a face-to-face meeting is called for, can you represent your friend? And the answer again is no. Right.
So like people that like just have like accounting practices that aren't CPAs, aren't enrolled agents or anything, if they prepare the tax returns and then they get a notice for the tax return that they prepared, they're not allowed to respond to it?
They're not supposed to be practicing before the IRS, right?
I guess you could write a letter and on your friend's behalf and have your friend sign off on it and send it as if the friend is representing themselves.
But, well, that's another way of doing it. Say again?
There's another form that you can file with your representative.
A family member, yes, because that's the next question. So we're gonna steal my thunder here. But problem 1-10, you're still not admitted. Your parents receive a letter from the IRS notifying them of their joint federal tax return for 2014 that's been selected for audit, lucky them. Wishing to get their money's worth from all your tuition, or all the tuition bills they have paid on your behalf. They asked you to represent them. Can you? Why or why not? And the answer is, when you go to 10 point.
Exception, limited, that's the limited time where you may be able to.
Yeah, if you look at 10.7, if you guys want to turn. What page is it on? 332, right? 10.7, and we look at C1I. C1I, individual may represent a member of his or her immediate family. Right? Does everyone see that? So, what we're going to do, you guys have been patient, we'll go for, as opposed to, usually when I teach a 3-hour class, we try to keep the breaks to 8 to 10 minutes. 4-hour class, we'll go for a whole 15 minutes. Now, I will leave up here. I have, downstairs, I saw the first floor, you will see there's a sign that says vending machines, okay? And it has cookies, it has crackers, it has stuff like that. And then there's a soda machine right next, but there's a you can quote unquote purchase sodas for $1. Apparently they're running that. So if you want to get
put the dollar in the envelope.
You just gotta put the $1 in the envelope. There's restrooms outside. And we'll come back here, and if you have any questions, I'll be up here. And we'll come back here about 5 of, you're right, about 10 of